Thank you. Good morning, everybody. I'd like to call the meeting to order and acknowledge that we are in Treaty 1 territory, the home and traditional lands of the Anishinaabe, Ojibwe, Innu, Cree, and Dakota peoples, and in the national homeland of the Red River Métis. Our drinking water comes from Shoal Lake 40 First Nation in Treaty 3 territory. My name is Mark Boreski. I'll be chairing this session today. With me on the panel are Michelle Duncan and Doug Marks. The assessor today is Stephen Lobenstein. Our administrative personnel is Phoebe Graywood. To the Zoom participants of the hearing, please note, you are placed in the waiting room until your property is called upon. When it is your turn, you will be admitted into the meeting. Kindly follow along on the City of Winnipeg's Board of Revision YouTube channel for the hearing process. Once the host admits you into the hearing, please close or mute your YouTube player. You will then be permitted to speak with respect to your property. Once your hearing has concluded, you can leave the meeting. We'll be hearing applications for revision of the assessment roll in accordance with the Municipal Assessment Act. The matters for which revision is requested have been described in each application, and we will limit discussion to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matters must be sworn in. Be advised that comparisons of assessments of properties are not considered evidence of market value by the Board of Revision. The Board of Revision is appointed annually by Council and is independent of it and the City Administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order that will be mailed to all parties as soon as possible. Please note that the Board's decisions with respect to an application may be appealed to the Manitoba Municipal Board if the matter pertains to assessed value or classification, or to the Court of King's Bench if the matter pertains to the application of exemptions from taxation. Should you wish to appeal, information on how to do so will be included with the Board's order. With respect to the hearing process, I will confirm the points of appeal with your property to be addressed with each applicant following the swearing in. We will then have the assessor's testimony, followed by questions that the applicant may have, and then the applicant's testimony followed by questions. Each side will have an opportunity to summarize if they wish. Once all of the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each item on the docket today. The session will close after all the applications have been heard, and the Board will deliberate in private and make its decisions. You will receive the Board's decision by registered mail as soon as possible. As information, all public hearings are live streamed, recorded, and will be part of the public record. We are having only one item on the docket today. Is that correct, Ms. Graywood?
Yes, item 2.
All right. In that case, could you please affirm the assessor's and the applicant's testimony?
Mr. Lobenstein, please state your full name.
Stephen Lobenstein.
Do you affirm the evidence you're about to give at this hearing is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Mr. Story, please state your full name.
My name is Jared Story.
Do you affirm the evidence you're about to give at this hearing is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Thank you very much. Then the sole item on our agenda, item number 2, the others having been withdrawn, is 1500 Clarence Avenue. Mr. Lobenstein, when you are ready, could you proceed with your evidence?
Sure. The roll number is 030705100000, 1500 Clarence Avenue. I'm just going to quickly scroll down. Oh, sorry. And the assessed value is $11,540,000. You can see there's a recommendation. We are requesting that the burden of proof be placed on the applicant for non-cooperation under section 53(3)(b) of the Municipal Assessment Act, and if a reduction in assessment is ordered, that it follows section 54(3.2) of the Municipal Assessment Act. So would you like me to proceed with that evidence first?
Yes, please.
Okay, if you scroll down to my page 11, you can see that this is the Canada Post signature that we've received. So it has the tracking number and the product name And he has a signature date of, it looks like June 6th, June 12th, 2023. And there is a signature there typed in that says AVIP. So this was signed for. As well, you can see that there is another tracking number on page 12. It shows that the signature is available, the time it was delivered at, and when the item was processed initially at the Canada Post location. As well, we have a letter on page 13 showing that that's the same tracking number in the top left corner, the LP 661115272CA, that matches the tracking numbers on the above information I just showed you. As well, in this letter, you can see that this is for CWS Logistics Ltd. They are located at 1664 Seal Avenue. So although this is for the property address of 1500 Clarence Avenue, all CWS Logistics owns this property, and they want all of their tax information sent to 1664 Seal Avenue. So we can see that that is the mailing address. That is where we sent all the tax information for this property as requested by this company in a letter they sent to the city of Winnipeg in 2014. As well, on page 14, you can see the mailer that we sent out for the property. And it's also on page 15 as well for any tenants that they may have. So it should be noted that they have not sent in a mailer since, I believe, 2014. So they have been chronically non-compliant for 10 years now, despite the fact that we've consistently sent out mailers and there are signatures for them. So we feel that the burden of proof should be put on the appellant, and that non-compliant should be enforced. So that is my presentation, and I'm open for questions. Thank you.
All right. Mr. Story, do you have questions?
I have a few, Mr. Chair, yes. So Mr. Lobenstein, and just to be clear, we don't have an issue with the fact that these are going to the Seal Avenue property. We agree with that, and no issue with the tracking number. My concern here, well, sorry, I'll ask you a question, save my comments for my presentation. You'd mentioned that the signature was typed in, correct?
Correct.
Okay, but do we not usually see a signature that is done sort of with a, I don't know how to describe it, but it's sort of a, they do it on a little screen, they give you a little stylus and you sign it, and then what the result of that is actually like an image as opposed to a typed in signature.
Sure.
Is that not correct?
I mean, we've seen that as well. I mean, it can be typed in as well. A signature could be a simple X. It could be a line. As long as somebody's received it, Canada Post said they've sent it there, they got the signature, it was delivered, this is the signature.
Okay. You'd mentioned that they'd been delivered in the past. Do those other forms have a typed in signature, or are they the more typical it's the image?
Yeah, so they actually have both. It's interesting. So I was looking at this, they have a signature and they actually have a typed in name as well of somebody who's received it.
Okay. But for this one, it appears that that's not somebody's name, presumably. I think that would be shorthand for a very important person, perhaps. Is that your
I can't say. That could be initials for somebody's name.
Okay. Okay. I'll leave my questions there, Mr. Chair.
All right. Ms. Duncan, do you have questions?
No questions, thank you.
Mr. Marks?
No questions for me at this time. Thank you, Mr. Chair.
So, Mr. Lobenstein, you're saying that there was a signature and the name was also typed in on the form?
No, I was asked about previous. So they've been non-compliant since 2014. So I looked back at all the other documentation we've sent. Previously, yes, there has been other times when there has been a signature and also a typed in name is what I was saying. For this situation, they just have the three letters that were typed in to confirm that they received it.
So they receive the the form how? In person or by mail?
It would have been in person in this situation because it would have been delivered and a signature would have been taken.
And that was
So-
taken by Canada Post, not by
Right.
an assessor.
Yes, by Canada.
So do you have any idea how is a VIP typed into the form?
They have, similar to what Mr. Story said, they have pads that you can sign in. I guess in this situation, it was typed in. I mean, I wasn't there to witness it, how they did this, but Canada Post says there was a signature. You can see that on my page 12, that it is available at 10:14 a.m. It was delivered and signature is available. So this is the signature they received.
So the signature is available from Canada Post and you did not get it?
No, we got it. It's right there. You're looking at it. That's the signature.
I don't see a signature. Sorry, where am I to look for it?
On page 11, at the bottom, it says signatory name. It says
Yeah.
AEIP. That would be the signature.
Yes, but I don't see a handwritten signature anywhere.
I
Correct?
mean, it doesn't have to be handwritten as long as it says it's been received. This
Hmm.
is it. So Canada Post has delivered it. They've typed in, whoever received it typed in AVIP into whatever, I guess, computer they have at the time instead of a signature, and that's it.
And then hands it back to the
And
postal
hands it
worker.
back, and Canada Post says, we have delivered our document. We have a signature at this time.
Okay, Mr. Story, your evidence, please.
Yes, just very quickly, Mr. Chair. I think you've touched on something that is giving us some concern. We don't believe that this entry constitutes a signature. It's not traceable. I think that I could be wrong, and Mr. Lovenstein may know more about this than I. But I believe that when you're signing for registered mail, that is indeed what this is. A track package requires a signature on delivery. You often have to show identification. This is simply there's no way to track this. So I spoke with the owner and I asked, have you received this? And he said, no, he's never actually received any of these. In fact, I sent him a blank one so that he could physically see what this form looks like. They have been receiving other notices. They have been compliant with paying their taxes. However, this is not traceable to anyone in the company. We don't know who. I don't believe that it's somebody's first initial and last name. I think that we don't know who signed this. So based on the fact that this is the penalty is quite severe, as you're all aware, I don't believe that it's appropriate to apply it in this case, because I don't believe that this signature would satisfy the burden of proof. So, and just for background, Mr. Chair, we have not appealed this property in the past. So this is a new issue to us. When the issue arose, we spoke to the owner, and he is going to ensure that the address is correct, and the seal address is indeed correct, but that everything is sent to his attention. So from our perspective, this is we don't know who this person is. We can't guarantee that it was delivered. In fact, the owner is telling us that it was not delivered to him, and it would be his primary responsibility to comply with the assessor's request. So ultimately, we would ask that the penalty not be applied. We recognize that the city does require this information. We've now made steps in good faith to correct the issue, but based on what's been provided here, sir, we do not believe this is a viable signature that ought to lead to this severe penalty. So based on that, we would ask that the board not apply the penalty in this specific instance, and I thank you.
Mr. Lovenstein, questions?
Yeah, so you stated that they have never received the income and expense mailer.
He said that he has not ever seen one of these mailers. That's right. And he fills them out for other markets. So they're across Canada, and he does fill out ARFIs in other markets, but he's not filled them out in Winnipeg. He's not seen one. Yeah.
But they have received their notice of assessment so they could appeal this property. They have received their tax bills to pay for their taxes. So all this is sent out the same way through registered mail. So they've received all of this, but they've never received a single income expense mailer, even though it's going to the same address from the city of Winnipeg.
I'm sorry, the tax notices, are you saying they're sent out by registered mail?
Or, yeah, well, they're sent out, yes, by mail, or they can find them.
Right,
Or they
but
can
not by
find them online if they like as well. So they've
But just to be clear, they're not, yes, they do receive their other documents, but their tax bills are likely paid online. I'm not sure. I'm not sure. I'm simply relaying with the owner.
Sure, they can pay them online, but they receive paper copies as well.
Sure, yeah, that's
Okay.
fine. Yeah.
So throughout all this time, so they receive all this other documentation, but the one documentation that's needed right now, because it's a penalty, they're saying they're not receiving it. Even though there are signatures for in the past, a signature name and initials through since 2014 all the way up saying they've received it. And this time there is a signature, it's just a typed in signature to the same address as all the other documentation, but they've never received it. This is what you're saying.
So, Mr. Lovenstein, what I've said to you is we've not appealed this property in the past. So this is not an issue that we've been made aware of, right? So this is our first time dealing with it, and we are trying to work through it appropriately and ensure that it doesn't arise again. We're not, personally, we don't like having this discussion any more than you do.
Fair.
Yeah, so I agree that there are a number of different types of documents that are sent, although I don't want to misrepresent that many of those documents are indeed sent by, call it traditional or snail mail, not registered mail, and they are compliant in that regard. But based on the owner's comments, he has not seen the income and expense mailers, and I can only relay what he has told me. So I understand your concern, but no, he's not received it, and frankly, I don't know. Perhaps there's a break in the process here, because I don't know who this or who would have signed ABAP as opposed to simply signing their name. That is, we've looked at many of these, and I know that you have too, and this would be very, very atypical. So that's the information that we have.
Okay, and I understand you said that you haven't appealed this, so you've spoken about it, but you did say the owner is aware of income expense mailers because he's filled them out before for other properties.
Well, I had to have a long talk with him about this to try and get to the bottom of what's going on with this property for this appeal. So I mentioned that, you know, there are annual income and expense requests that are mailed out by the city, and he had mentioned that he fills them out for other markets and it's no problem, but for some reason he's not getting them in Winnipeg. So I sent him a copy of a blank form so that he could see what one looks like, and then I also sent him a link to the request to change address. So that was just yesterday that I spoke with him again about this. So I presume that he will be making some changes so that everything is sent to his attention going forward, and to ensure that this doesn't happen again.
Great, those are all my questions.
Okay. Mr. Marks, do you have questions?
No, I do not. Thank you.
Ms. Duncan, do you have questions?
Yes, a couple. So again, maybe this might have been more appropriate for the city assessor, but I'm sure Mr. Story would be aware as well. So has this property ever received a city penalty for non-compliance in the past?
I don't believe so, because I'm just going through my records, which go back to there's a sort of a legacy file in 2010, 2011, but most of our reviews are in 18, 19, and then 25, 26, and they were not appealed. So the penalty only becomes germane to the discussion on appeal. No, there's not been a penalty applied, but there's also not been an appeal. So that's how that would work.
Mr. Chair, I would just like to ask the city assessor that, has there ever been a penalty rendered against this property owner for this property for non-compliance in the last 10 years?
No, because they've never appealed the property, so it's only applied if you appeal.
Okay, sorry, that's what Mr. Story had said, but I just wanted to know for sure. And would, based on their, obviously, this is again for the applicant, based on their familiarity with the need for mailers, would that not be in due diligence, a question that would be asked? Like, where's my mailer? I mean,
I'm not sure. I would be speculating. I know that they are aware that our fees or annual requests for information are sent out in different markets. I mean, different taxing authorities have different taxing schemes, so it would be slightly different, presumably in different markets, and the penalties are different in different markets as well. So I know that he is aware that there are annual requests for information, but by his admission, he has not received them in Winnipeg. So, but it's a good question. I'm not sure why he didn't say, well, why am I not receiving this? But it is, again, it really becomes a point of concern on appeal more than anything. If you don't appeal and you haven't sent it in, there would be no, the city doesn't chase you down at that point to say that you've been non-compliant. They make the two requests, the first by regular mail, the second by registered mail. But he's saying that he hasn't received it. So it's a good question, but I suppose that's a long way of saying I'm not sure. I would be speculating if I were to answer.
and then I guess my last question is, the city had advised that they have received signatures in the past in various forms. Has the owner said to you they've never ever received a mailer? They don't know how any previous requests would have been signed for?
Yes, that's correct.
Okay. Thank you. No other questions.
Mr. Chair,
Yes,
I got one question if I could.
yes.
Okay, apparently the owners have received the snail mail regarding these items, but they haven't have received the mail by registered mail, but they're saying they haven't, or I'm a little confused on this whole
I'm sorry,
thing.
sir. I missed the first part of your question. Would you mind
Okay.
repeating that?
The
Sorry.
first notice was sent out by snail mail,
That's typically the process. Yeah.
but they have been receiving other snail mail.
Well, presumably,
From
because
the city.
the assessor's point is that if they're receiving tax notices, which provides the documentation that you are required to appeal. Although that being said, you are able to receive those that notice publicly, so that's not necessarily correct. I don't know how they are receiving their snail mail. I know that they are not in arrears in terms of their taxes, as evidenced by the assessor. So I'm not suggesting that they're not receiving snail mail, but clearly there's an issue with this piece of registered mail where it was not received by the appropriate person, and we don't. This is a signature effectively of unknown origin, so we don't know who it was delivered to. But I presume they are receiving their other mail. Yes.
So the property owner doesn't know how this one was signed or by whom?
That's right. That's exactly right. He doesn't know who that is or who would have signed a VIP, and we're all sort of a little bit concerned that there's no. There should typically be a signature, like an image of a signature. When you pick up a piece of registered mail, there's a little pad and a stylus, and you sort of write it onto that screen. And that's typically what. Pardon me.
And there is a keypad on that device.
I think. Well, it's a good question. I'm not sure. I think there may be, but I don't recall offhand. But typically, we do see a signature, the image, and then we'll see either a name or initials. So in this case, it's a bit odd, and it's odd that the postal worker would have submitted it without identification and simply accepted a VIP. That doesn't tell us anything, and it provides us no recourse to, if we have a situation like this, to determine who would have signed for that. So that is the issue before us today.
Does the post office back up the signature as it is, or?
I'm not sure. I went in and I tried to type in the tracking number on the Canada Post site, but it appears that they only archive those for, I think they said, in one place I saw 45 days, and another place I saw 1 year. So I'm not sure how long they keep them on file, but I don't think they keep them indefinitely. And I was not able to return any results by typing in this tracking number.
Okay, thank you. No further questions, Mr. Chair.
Okay, and I have no questions. So we will take a recess now in order to deliberate on whether the penalty will be applied and the onus will be reversed. So, Ms. Graywood, could we have you shut the feed off for a while and make the arrangements so that we can do this in private? Thank you very much. All right, we have deliberated on the question of whether there will be a reversal of onus and the penalty applied due to lack of return. We will reverse the onus. And Mr. Story, that means that you will present your information first.
Okay, thank you, Mr. Chair. Okay, so it's file 243072, roll number 03070510000. And Mr. Chair, based on the application of the penalty, we will simply request confirmation at this time. So would you like me to continue, or may I stop there with the request to simply confirm the file at this stage?
A minute. Mr. Lobenstein, do you have questions about that?
I have no questions, no.
Ms. Duncan?
No questions, thank you.
Mr. Marks?
None for me, thank you.
All right, and so Mr. Story will then not be presenting evidence to seek a different value, is that correct?
That's correct, sir. We will simply request confirmation at this stage, yes.
All right. In that case, that concludes the information about this matter. And we have done the one item that was on our docket. Therefore, our hearing today is concluded. And thank you very much for your attendance and your information.
Thank you. Thanks, Chair. Thanks, everyone.
Thanks, everyone. Thanks, Steve. Talk to you soon.
Have a good day.
Thank you.